In response to the recent issues regarding convicted former Mayor Antonio Sanchez of Calauan, Laguna, I would like to make the following clarifications in behalf of the Supreme Court. First, the Supreme Court did not order the release of Mayor Sanchez in its recent decision in the consolidated cases entitled Inmates of New Bilibid Prison et al. Versus De Lima et al., GR number 212719, and Edago et al. Versus De Lima et al., GR number 214637. In the said consolidated cases, the primary issue was the legality of the implementing rules and regulations, or IRR, of Republic Act 10592, which was jointly issued by the DOJ and the DILG in 2014. In particular, the provision of the IRR which called for the prospective application of RA 10592. RA 10592 was a law enacted by Congress in 2013, amending certain provisions of the revised penal code. It basically increased the good conduct time allowance and other time allowances to qualified inmates or prisoners. The law also extended the grant of time allowances even to those undergoing preventive imprisonment. Thus, the basic and primary issue in the said cases was whether or not RA 10592 was to have a prospective application or a retroactive application. In deciding the case, the Supreme Court applied the fundamental doctrine in criminal law, which states that penal laws which are favorable and advantageous to the accused are applied retroactively. Thus, the Supreme Court struck down the provision in the IRR and ruled that RA 10592 was to be applied retroactively, as it had the effect of lowering or reducing the sentences of prisoners, hence favorable to them. Second, the policy to increase the good conduct time allowance and other time allowances did not come from the Supreme Court, but rather it stemmed from RA 10592, which was a law enacted and passed by Congress in 2013. The Supreme Court merely interpreted the law. And finally, the implementation of RA 10592 is also not within the jurisdiction of the Supreme Court, but rather, like all laws, the implementation and execution of RA 10592 is left for the executive branch of government. Again, the judiciary or the Supreme Court only interpreted RA 10592 and ruled that it be applied retroactively. Thank you.